that Jack Smith has failed to try to prosecute Trump before 2024. That was his entire quest. That's not justice in America. That's lunacy.
Judge Chutkan actually acknowledged that Jack Smith's request is, quote, procedurally irregular, and then she let him do it anyway.
It was, frankly, motivated by the orders of the judge in this trial, who has, it appears to me, been extremely favorable toward Trump.
Kamala Harris exploiting Jack Smith's 165-page disgusting dossier, fully intending to rig the election, now colluding with Kamala. Kamala released this advertisement, we'll let it play here, showing the actual excerpts from Jack Smith's report. Look, literally quoting Jack Smith. Jack Smith's evidence against Trump is pretty damning, says former prosecutor. Playing this, taking excerpts from the report. The report is in the background. Pressuring officials, says Kamala. Spreading lies, encouraging the mob, blah, blah, blah. He wrote it for her campaign. Chutkan delivered it for her campaign. And guess what? It's paid for by Harris for president. And Harris runs the Department of Justice with Joe Biden. She's the vice president of this country. And Jack Smith is not an independent counsel. He's a special counsel, an illegitimate counsel, someone who has been thrown out of court for being illegally appointed. Never was appointed at all. Just took kind of a fake oath that people have questions about and then is now prosecuting Trump. Okay. Now writing a report that Chutkan published for all of America to see so Kamala can exploit it. It's collusion. This is government colluding with itself. It's Kamala's own entities writing a report that then Kamala can exploit. It's Banana Republic nonsense. And guess who's even calling it out? Elie Honig. You know him. I've got a clip of his. He was having a conversation on with CNN about this and called him out, wrote a whole post about it, calling it a cheap shot, saying that Jack Smith's big fat dossier is a cheap shot. But he says that Jack Smith has failed to try to prosecute Trump before 2024. That was his entire quest. That's not justice in America. That's lunacy. So instead, he bent ordinary procedure to get one last shot. He dropped a 165-page doorstop of a really quite boring filing that we read through here. And then suddenly, Judge Tanya Chutkan, who suddenly claims not to care about the impending election, despite racing to get this case to trial before the election, now then published this and redacted the obvious names, like nobody could tell who it was. Arizona governor? Give me a break. Now, Elie says that there are two headlines here. The immediate takeaway is that this is an oversized brief. He got permission to file 180 pages. It was 4 times the normal size. And there's new details about Trump. Not really. But the larger, if less obvious headline is that Smith has abandoned any pretense. He'll bend any rule. He'll switch up on any practice so long as he gets to chip away at Trump. At this point, there's simply no defending Smith's conduct on any sort of principled or institutional basis. And this guy's a former federal prosecutor. But we need to know this stuff before we vote is a nice bumper sticker, but it's neither a response nor an excuse for Smith's unprincipled norm-breaking practice. And the Justice Department waited over 2.5 years to indict him in the first place. But here is Elie himself explaining this over on with Cable News.
A newly unsealed filing from special counsel Jack Smith is putting Donald Trump's efforts to overturn the 2020 election back in the spotlight. The 165-page filing lays out the bulk of evidence in the government's case against the former president. But our next guest, CNN legal analyst Elie Honig, is calling the move, quote, a cheap shot in a new piece accusing Smith of, quote, bending ordinary procedure in this new filing. And Elie Honig is joining us now. Of course, he's also a former U.S. Assistant Attorney for the Southern District of New York. Elie, great to have you here. I want you to talk more about your criticism because it seems to be really centered around the timing of this move. Of course, we're just 1 month out from the election.
Yeah, Jessica. So my criticism here is that what Jack Smith and the judge did is they reversed the ordinary process. The way it works under the rules of procedure, I handled thousands of cases every time, is the defendant, in this case Donald Trump, files his motion first, and then the prosecution responds depending on whatever that motion is. What Jack Smith did is he said to Judge Chutkan, well, I need to go first here, and I need to file a 4 times over-length brief. Judge Chutkan actually acknowledged that Jack Smith's request is, quote, procedurally irregular, and then she let him do it anyway. And because of that flipping the ordinary procedure on its head, that's what enabled Jack Smith to put this brief in October, shortly before the election. So I think there's a big problem with that. I think it runs counter certainly to the spirit, and I believe to the letter of DOJ policy, that you try to avoid doing anything that could impact an election too close to an election.
Yeah, at least
and you've even compared this
right
to James Comey reopening the email investigation into Secretary of State Hillary Clinton just days before the 2016 election. Clinton's actually responded reacted to that idea, and I want to listen to what she had to say.
I think the situation is completely different, and this is in the context of an ongoing criminal procedure that the special counsel has brought against Donald Trump many, many months before the run-up to the election. It was, frankly, motivated by the orders of the judge in this trial, who has, it appears to me, been extremely favorable toward Trump. So I think that there's nothing out of the ordinary.
What do you think about that, Elie?
Yeah, Jessica, well, all respect to Secretary Clinton. She's the one who suffered the consequences for James Comey's, I believe, outrageous conduct in 2016. DOJ found later that it was outrageous. The problem, though, with Secretary Clinton's analysis of the Jack Smith case is, respectfully, she's got her facts wrong. First of all, she's confusing the judges here. I think she's thinking of Judge Cannon, who, yes, has ruled almost entirely for Donald Trump, but that's the judge in the other case. The judge here is Judge Chuck, and I get it, similar names.
Not really similar names, and Cannon did not rule over and over and over for Trump. In the Florida case, in fact, she denied many of his requests to dismiss the case for all of the other problems in that matter, like selective and vindictive prosecution, there's statutory problems, there's immunity issues, many different issues. Finally, she dismissed it based on his illegal appointment. But those other matters, she ruled against him on those and gave his case a much more fair shake than he's seen anywhere else.
Judge Chuckin has ruled almost entirely against Donald Trump. More to the point, the last thing we just heard Secretary Clinton say was, quote, there is nothing out of the ordinary. But as I described before, the way they flipped this procedure is the opposite of the ordinary. They reversed the actual way that motions are done. You can talk to 100 former federal prosecutors who've collectively handled 100,000 cases. They will all tell you they never filed their motions first. And I think it begs the question, what was the rush here? Why did Jack Smith have to ask for this, to quote Judge Chuckin, procedurally irregular approach? So I respectfully disagree.
Election. That's why they did it, because they're colluding with each other. They're working together hand in hand to try to stop Trump, and they're exploiting the justice system to do it. Now, the Supreme Court is back in session, and NBC News is wondering if the Supreme Court's going to have to come out and settle this again. Could you imagine a Bush versus Gore situation with Trump and Kamala? Oh, gosh, that'd be bad. But the Supreme Court started a new term, and there may be some cases on the docket. It's a 6-3 majority. People are having flashbacks to Bush versus Gore in 2000. Nate Parsley says there's going to be something. I don't think that they're going to hear a case before the election, but there will be attempts to draw them in. Officially started a new term on Monday. All 9 justices appeared in the courtroom. It was the first time the justices have been seen in public together since the previous term ended, including Trump's immunity ruling. The court also issued a long list of cases it declined to hear this time, including an abortion-related dispute between Texas and Biden, declined an appeal brought by Elon Musk. That followed action on Friday. They announced 13 new cases they'll be deciding in the coming months, including a bid by gun companies to throw out a lawsuit brought by Mexico to hold them accountable for violence there. I think that came up in our members-only morning stream today from Nellie. Election law experts say it was too early to say whether any potential case could make its way to the Supreme Court. Of course, we're going to keep our eye on it. Lawsuits are already circulating. We've covered several of them here. In Pennsylvania, there's ongoing fights about whether mail-in ballots can be counted if voters did not include the correct dates, for example. In Georgia, there's another one over purging voters from the rolls. Stakes are huge in court, and of course, that's what we're covering here. So we'll keep our eye on it, see what makes its way through.